Now everybody can hear you.
Okay. Now I'm turning.
Okay, what are you on now? Because I can see Angel and her name.
Morning, Your Honor.
Possession of a firearm. Her risk assessment instrument gives her in section A on the top. It gives her 10. In that case, the risk assessment was double scored for the point 3 points when the charge already included a firearm. Also, in the case of
Judge, the state would only ask, based on the case law, the state would agree that she does score home detention. The 3 points should be taken off. The state would ask for some type of GPS monitor for the juvenile.
Okay, we're good now. All right, good morning, ladies and gentlemen. My name is Judge Levy. We're beginning the first appearance court today. I want to advise everybody who's here as a defendant that you do have the right not to say anything. Anything that you say may be used against you if the case were to go to trial. For any defendant that's unrepresented, you do have a right to counsel, and if you're unable to afford one, one will be appointed. You also have the right to communicate with your attorney, with family or friends if they are here, and I will give you that chance. If there is a possibility that your case may be resolved today by a plea offer, I will let you know and give you that opportunity. Okay, the first person I need to see, and we're taking a couple of cases out of order, Terrence Saquon Turner. Hello, Mr. Turner. I can't hear Mr. Turner. Oh, okay, perfect. All right, so Mr. Turner, you're here on a capias, and I do find probable cause. What does the state recommend for a bond?
Judge, the state, based on priors, would recommend no bond. He has a 1997 delivery of cocaine, 1997 agbat, and battery on a detention employee. 2008 trespass, 2009 possession cannabis, resisting without, and corrupt by threat against a public official, 2008 grand theft auto, a 2009 felony battery, which was declined, a 2009 firearm by a convicted felon, which was no pros but later refiled, 2 counts, a 2011 firearm by a felon, 2011 3 cases which were ultimately no pros, exposure of sexual organs. And then the pending case of the 2017 felony battery domestic strangulation. Based on priors, the state would ask for no bond.
Okay, and let me hear from the public defender, please. If you don't, do you wish to say anything?
Speak to her.
They revoked my bonds in this case yesterday. I had a hearing in misdemeanor court where they revoked my bonds that I've already previously paid for.
Well, they revoked your misdemeanor bonds.
Well, I didn't have any misdemeanors at that point. And the bond that I bonded out on was like $9,500 total. And those are the bonds that I was out and on before I was detained and held in custody.
Okay, well, you have a domestic violence capias that was issued in this case for a felony battery with a prior conviction. The court is going to hold you no bond at this point in time, and your attorney could always seek a bond from the trial court.
Well, I don't consent to it. If it requires one, I don't
He's entitled to a bond?
being held without a bond because I was detained already forcibly and against my will without a probable cause.
All right, I'll tell you what, Mr. Turner. You are entitled to a bond on this case, so under the circumstances, I'm going to set bond at $30,000. Good
Your
luck.
Honor, would you consider a $5,000 bond?
I will consider it, but your request is denied. You could always seek a lower bond from the trial court. Okay. Omar Finnegan? Hello, Mr. Finnegan. Mr. Finnegan, you're here on an ad charge for introducing contraband into a detention facility. I do find probable cause. You have a $1,000 bond. You're welcome. Mark Mashun Derfaka? Hello, Hello, Mr. DeFalco.
Your Honor, if I could just ask Mr. DeFarca. Mr. DeFarca, do you have an attorney already, Mr. Anthony Britt?
Yeah, that's my attorney.
Do you want to proceed without him this morning?
No, I don't want to receive without him.
Okay, so you want him here?
Yes.
All right. Your Honor, we could wait then. I know BSO wanted to talk about it, whether he has an attorney adjustment.
Why you taking?
Okay, is,
Attorney coming today.
Does he know to come this morning?
Don't show up on a Saturday.
You got to put the mic on.
we can't hear.
They had changed my cases. I've been here like 30 days and they just changed the cases yesterday.
Does he know you're a magistrate this morning?
No, sir.
Your Honor, then what I would ask if we reset this for tomorrow and then the court reach out to his attorney.
Can I do that, Patrice?
Yeah, you can, but yes, you can.
Okay, Mr. DeFalco, if you don't want to proceed today without your attorney, I could have my clerk call up your attorney and let him know that we'll put your case on for tomorrow.
Yes, ma'am.
Okay, so I'm going to reset Mr. DeFalco for tomorrow. We'll see you back tomorrow, Mr. DeFalco. And if you could reach out to the attorney and just let him know. That's fine, just leave a message, yeah. Okay, Elizabeth Perez Mendez. Okay. Hello, ma'am.
Hello?
Miss Mendez, you're here on an assault on law enforcement, domestic violence battery, possession of cannabis, and drug paraphernalia charge. I do find probable cause. Bond on the battery charge I'm setting at $2,500, and I'm ordering no contact with the alleged victim in the case. Good luck, ma'am.
Your Honor, just on the probable cause for Ms. Mendez, I did get a chance to speak to Ms. Mendez, if I could just inform the court. Her and the boyfriend do live apart. Unfortunately, Ms. Mendez is currently homeless. She does get her mail at Broward Outreach, so she is reachable by the court. She does have a good address for mail. When I looked at the probable cause affidavit, I did want to bring it to the court's attention that the victim did not cooperate. It was not the victim who called the police. I believe it was actually Ms. Mendez who called the police, that it was a female who called police. The police show up. The victim did not cooperate with the officers. He did not complete an affidavit. He did not want any attention. It was a third witness who told the facts to the officer, so I don't believe the victim wants to pursue charges as he did not cooperate with the officers. As for the assault, what the officer said is that Ms. Mendez allegedly spit in his direction, did not touch him. And when it came to the cannabis, what the officer refers to is a quote-unquote device. He does not specify what the device is. I don't know if it's a lighter, because he doesn't give us any specification as to what the device actually is.
Okay, hold on one second. Okay, I don't read the probable cause affidavit the same way you do, counsel. It states that the independent witness advised that he observed the alleged victim pulling a black luggage in the rear of the address as the defendant, Ms. Mendez, hit him in the back of his head with an open hand several times. So,
I understand what the third party says. It's just the victim himself
okay,
didn't speak to officers, didn't complete an affidavit.
I understand your position.
No, I'm just-
You could address the trial court in that matter. I am setting bond at $2,500, and as far as the cannabis, the device that the officer found field tested positive for the presence of cannabis. There's no amount of money that you have to pay on the cannabis charge. But it's $2,500 on the battery. Good luck.
Judge?
How I'm gonna pay when I'm homeless? I don't got no money.
Ma'am,
I'm in the streets.
I understand you have a $2,500 bond.
Judge, if I may,
Yes.
has Your Honor set a bond amount for count one, the assault, Leah?
No, I didn't.
But she doesn't have to.
Yeah, it says,
And
No
she
char-
says no bond attached. She doesn't have to.
right,
attach a bond.
I'm not going to. I'm only setting a bond on the battery. Good luck, Miss Mendez,
So I'm staying in jail?
until you go to the trial court, or until you bond out. Giovanni Castano? Hello, Mr. Castano.
Angel.
Morning.
Mr. Castano, you're here on a domestic violence battery charge. The court does find probable cause. I'm setting bonds in the amount of $5,000 and ordering no contact with the alleged victim. Good luck.
Hold on one second.
He's saying pretrial spoke to him. Pretrial does speak
Your
to
Honor,
a
he
lot
can't
of
afford a
people.
$5,000 bond. Would you consider some type of pretrial release?
I did.
Madam Pretrial, what?
No, I heard him saying pretrial spoke to him, and that is true. It does appear, however, Your Honor, he does have a warrant out of South Carolina that is pending at this time.
Oh, you gotta pay it.
Okay. Mr. Castano, since you do have a pending warrants in South Carolina, I'm not referring you to pretrial. You're gonna have to post the bond.
Would you consider reducing it to 1,000?
Does he have any prior state?
Judge, from what I can see, he does have a 2016 possession of cannabis. I don't see any other priors
Your
besides
Honor, he
that.
has priors out of the state of Illinois as well as the state of South Carolina. I'm going to them so I can tell the court exactly what it is.
Okay, tell me the,
2008 fleeing law enforcement officer. That was from Illinois. Defacing a firearm, it says, and resisting police officer in 2010. Escaping a peace officer. Aggravated assault on a person and a government official. That was subsequently null pros.
okay.
And then a 2010 adjudication for aggravated assault with a weapon on a person. He was adjudicated, sentenced, and then given 12 months probation. End of record.
All right, Mr. Castano, based upon the prior record that I have heard, I'm leaving bond set in the amount of $5,000. Jose Luis Villasenor. Hello, Mr. Villasenor. You are here on a domestic violence battery charge. The court does find probable cause. I'm setting bonds in your case in the amount of $2,500 and ordering no contact with the alleged victim. Howard Bosworth Bent.
Your Honor, can we have a moment, please? I'm trying to see if he can afford that. Okay, thank you.
You're welcome. Hello, Mr. Bent.
Good morning.
Now, Mr. Bent, you're here on 2 counts of domestic violence battery. The court does find probable cause. I'm setting bonds in your case in the amount of $2,500 on each charge and ordering no contact with the alleged victims.
Your Honor, I believe the court gave to you. We're asking for an order to take photos of Mr. Bent's injuries as well as an order for him to access his property. He wants to get phone numbers off his cell phone, which is in property at the jail.
Okay, any objection from the state?
None from the state, Judge.
Okay, the court will grant the public defender's motion. Good luck, Mr. Bent.
Thank you.
You're welcome. Darius Lopal Jenkins. Hello, Mr. Jenkins.
Good morning.
Mr. Jenkins, you're here on a domestic violence battery charge. The court does find probable cause. I'm setting bond in your case in the amount of $5,000 and ordering no contact with the alleged victim.
Your Honor, would you consider lowering the bond to $1,000?
State, does he have any priors?
Judge, I'm looking that up right now. I saw he does have a 2007 open carry of a firearm in which the defendant was pled no contest as charged. It doesn't say whether or not he was adjudicated.
It said drop.
It said, you have it as dropped? I have a pled no contest.
I have it as drop on his NCIC.
Anything else?
One moment, Judge. Judge. That's it.
Okay. Mr. Jenkins, the court is going to reduce your bond to the amount of $2,000 and no contact with the alleged victim. Let me ask you something. This alleged victim is your wife, but you're not living together?
That is correct, ma'am.
Okay. All right. Good luck, Mr. Jenkins.
Thank you.
You're welcome. Charles Anderson?
Good morning, Your Honor.
Thank you. Hello, Mr. Anderson. You are here on an ad charge for a domestic violence felony battery. I do find probable cause. The court's setting bonds in the amount of $7,500 and ordering no contact with the alleged victim. Good luck.
Okay.
Good luck, sir.
Thank you.
You're welcome.
Thank you.
Ernesto Demarit? Hello, Mr. Demarit.
Good morning.
Now, you're here on an aggravated battery of a person who is pregnant. The court does find probable cause. The court is setting bonds in the amount of $7,500. And I see you do have someone here. Hi, you're here for Ernesto?
Yes.
What's your name?
Tanova.
Tanova?
Yes.
Okay. And Tanova, you are the alleged victim in the case?
Yes, ma'am.
Okay. Is there anything you wanted to advise the court?
Well, I wanted to drop the charges.
Why?
We had an argument. I mean, I'm sure all the details are there, but you know, things got out of control, and I really didn't want him to get arrested. But of course, they explained that because of the state and all of that stuff, they had to take somebody. So they took him because I'm pregnant. So at this point, I would really appreciate if the charges are dropped.
Okay, at this point in time, the court can't do that. That's up to the state attorney's office.
Okay.
But let me take a look at the facts in this case again.
Okay.
Okay, it says here that Mr. Demarit grabbed you by your hair, slammed you against the front door, punched you in the left eye, that you
He slapped me.
Okay. It says you attempted to break free, but he had a good grip on your hair, that you fell to the ground on your back, and Mr. Demarit stood over you, grabbed you by your face, and that he then pulled your dress off.
Well, at some point, I think during the shuffle, my clothes just kind of, I had on a loose dress, so it
Right.
kind of pulled up, got pulled off.
Okay.
But we were back and forth. Both of us, had a lot to do with the argument. We were back and forth for maybe a day or two,
Okay.
as we are going through a little financial difficulty. So that is the reason why we started arguing.
Okay. Let me find out from the state if Mr. Demarit has any priors.
Yes, Judge.
Please.
The defendant has a 2012 Palm Beach sale of marijuana in which he was adjudicated guilty, a 2011 robbery, sudden snatching with no weapon, in which adjudication was withheld here out of Broward. That's the end of that report, but if I may just respond, Judge.
Yes.
The state would actually ask for a higher bond based on the facts of the case. The victim in this case had to arm herself with a knife to protect herself from the defendant as alleged in the probable cause affidavit. Your Honor has read through the facts. The state would ask for a higher bond in the amount of $10,000.
And state, just to let you know, there was a 2011 arrest for battery of a Hialeah that was subsequently now dropped. I thought the court would want to know about that battery as well.
Is that the same alleged victim?
It was out of Hialeah Police Department, Your Honor, so I don't have access to it.
Okay, okay.
I do show that he does have a protective injunction against someone named Ashley Maldonado.
Okay, and that's active?
Yes, Your Honor.
All right. Does the public defender wish to be heard?
Yes, Your Honor. It is our understanding that he is currently appealing one of those charges. We would object to a
Yeah, he
higher
is.
bond and know if you consider a lower bond.
Okay. At this point in time, and Tanova, I appreciate you coming to court and telling me how you feel about the charges, but the court is considering the nature of the charges and what has been alleged to have happened. And that,
Well, at the point when we were shuffling back and forth, his mom was there. So I'm not sure if they gave some of the details to the police because they had separated everyone that was there. His mom was there and I had a friend there as well. So like pretty much the four of us was in there. Like they were just trying to pretty much part us because I was doing a lot of, trash talking, bringing up old stories that kind of got to him, so.
let me explain something to you. No matter what you say, should not result in any physical violence. And that's what has been alleged to have happened. In addition, you are pregnant, you have an unborn child.
Correct.
He has an active restraining order against, from another lady in Miami. So based upon what I've heard his priors are and the nature of the
He has a
allegations.
restraining order
Yes.
active? Oh, I thought that was dropped.
No, I'm told it's active.
Oh, okay.
The court is going to leave the bond in the amount of $7,500. Since Tanova does want to have contact with Mr. Demerit, I'm going to order no harmful contact with the alleged victim.
Okay.
All right. Good luck, Ernesto,
Thank you.
and good luck, ma'am.
Your Honor, so he's allowed to have face-to-face contact, or is that just phone contact that the court is allowing?
He's allowed to have physical contact, no harmful contact. Don't tie LaRon Harris,
Your Honor, excuse me, what's the bond again for Ernesto?
$7,500.
All right.
You're welcome. Hello, ma'am.
I'm here for Dante.
What's your name?
Good morning.
Tandra Loud.
Tandra
Loud.
Lau? Okay, and what's your relation to Dante?
Fiance. We live together.
Oh, okay.
And I'm also the victim.
Okay. All right, hello, Mr. Harris.
Good morning.
Mr. Harris, you're here on a domestic violence battery by strangulation, and tampering in third-degree felony proceedings. The court does find probable cause for the domestic violence charges. I don't find probable cause in count 3, the tampering.
But also the domestic charge.
Hold on, I'm speaking. Can the state alert the court what the allegation is concerning tampering in third-degree felony proceedings?
Judge, the state would argue that by taking away the cell phone and forcing the victim to leave the area and go somewhere else to call 911 to make the report, that the defendant was tampering with the witness, or victim in this case.
Okay. Okay, and Tandra, what did you want to tell the court?
Wanted to request to drop the charges. We didn't have a fight. I don't know if you read the report. We did not have a fight.
Okay.
I came home after a party drunk, and it was like a pushing match. And he took my phone for the simple fact of, it's a long story. It was a new baby there, that he just had a baby on me, and I came home, and I was freaking upset.
What do you mean he had a baby on you?
We've been together for 2.5 years. He has a 2-month-old baby. It's not for me.
Oh,
And I came home, the baby was there, and, and I just came from my sister's partying. He's not a violent person at all. He's a gentle giant, like, seriously. Okay. He took my phone because he didn't want me to call the baby mom and start some shit. And he was just trying to calm me down. I woke up the next morning wondering where the hell he was at, and my neighbors told me I put him in jail.
Okay.
And the baby needs stuff right now, and I'm not gonna buy it. And I need him to come home. He's not a violent person at all.
Okay. Well, the facts that are listed in the affidavit was that he pushed you onto the floor. He was pushed you on the floor twice, and that you were on your back. You couldn't get up because he was pinning you down by your neck with his arm,
No.
and you began choking. You stated that you had to bite the defendant in order to get free. It's a little different story than what you're telling me
Even
today.
with the recorded story I gave the police, when they were saying, like, was it his arm or his leg? I said, I don't know. He was just trying to restrain me.
Okay.
And I wanted to go. He was just holding me, calm the hell down. I wanted to go and start some shit with the baby mama. And he
Okay.
just wanted to stop it. And even on the police thing, it is showed, it was like, well, did he hit you? He didn't hit you. Where did he have his hand or his leg on your neck? I said, I don't know. I was just going crazy. Like, if you look at the video, you'll see it.
And you think this is okay?
What? For him to restrain me?
What you're telling me?
What I'm saying? Yeah,
Yes.
I think this is okay because that's what it was.
Okay. State, does he have any priors?
Yes, he does, Your Honor. He has 2008, 1, 2, 3, 4 counts of burglary, unoccupied conveyance, attempted burglary, unoccupied conveyance, count of grand theft, and 2 counts of petty theft on that one case. 2011 possession of cannabis, 2011 trespass and petty theft, 2012 dealing in stolen property, burglary of a structure unoccupied, and petty theft, 2013 possession of cannabis, petty theft, DWLS, 2016 possession of cannabis, DWLS. End of that report.
Okay, so I understand, Tandra, he does not have any prior crimes of violence. The court is going to set bonds in the amount of $2,500 on count 1, $2,500 on count 2. I'm going to ROR him on count 3. And I will allow him to come home if you're living together, but he's to have no harmful contact with you. All right, good luck, both of
Thank you.
You're welcome. Myron Spencer? Hi, Mr. Spencer.
Hello, Miss.
Mrs. Spencer, you're here on a domestic violence battery charge, false ID. You have 2 capiases as well. The court does find probable cause. I am setting bond on count 1 in the amount of $5,000, ordering no victim contact. Currently, you have on the 2 capiases, you have a $500 bond and a no bond hold. However, you are set to go to court on the 15th of August at 8:30 to address that capias. Good luck, sir.
And the court did order a no contact?
I did, yes. Charles David Landon?
Yeah, he's on medical research.
Okay, so we'll reset Mr. Landon for tomorrow. I'm sorry, for tomorrow. Yeah. Brian Mejia Garcia?
Sorry, Judge, we said Charles Landon is reset to tomorrow?
Yeah, medical reset.
Okay, thank you.
You're welcome. Hello, Mr. Mejia Garcia.
Hi, good morning.
Oh, you are here on 3 charges. One's a domestic violence aggravated assault with a deadly weapon. One is a domestic violence battery by strangulation. And the third is a domestic violence battery. The court does find probable cause. I am setting bond at the amount of $7,500 on each charge. The court is ordering no contact with the alleged victim.
Your Honor, if I can make a bond argument, client advised me that he does live at home with his parents and that the alleged victim no longer lives there. Would you consider, he does have significant ties to the community. He's been here for 3 years. He works, he owns a car shop. Would you consider reducing the bond?
I will consider it. State, does he have any priors?
Judge, he does have a 2016 no valid DL. However, our office has been in contact with the victim. The victim does have safety concerns. the only prior that I've been able to find out of Broward was that one no valid DL. I'm checking CCIS.
I run his NCIC, that's all we need, so. it's
Okay.
interesting.
Okay, so what's the state's position as far as
Judge, the fact that
reduced bond request?
the fact that this is an ag assault with a deadly weapon, on top of the strangulation and the battery, the state would be requesting that Your Honor deny the defense's motion to lower the bond amounts on all 3 counts.
Okay. All right. The concern that the court has, Mr. Mejia Garcia, are the allegations that are contained in the complaint affidavit that you had your hands around the victim's neck and obstructed her airway. She was not able to breathe or scream for help. You placed a pillow over her head and proceeded to obstruct her airway. She tells the police she felt she was going to die and that he was going to kill her. All these events occurred in the presence of your 1-year-old daughter who woke up. And at that point, you removed the pillow. The victim asked if you were crazy. You said, yes, I'm crazy. I'll show you how crazy I am. And then you grabbed a machete from the closet and held it in your hand as if you were going to swing and stab the victim. This is grave concern for the court, what I'm reading, and especially in the presence of your 1-year-old child. I am going to leave bonds set at $7,500 on each count, no contact with the alleged victim. This is a matter that your attorney can address in the trial court seeking to get a reduced bond.
Your Honor, the court inclined to place this defendant on a GPS monitor after he posts his bond in light of the victim's concern and the fact that he said he was going to kill her.
Yes, I will do that. Mr. Mejia Garcia, if you do post bond, you're going to have to wear a GPS monitor based upon the concerns of the alleged victim. Okay, Jennifer Ann Danko Cleary.
Yes, ma'am.
Thank you.
Your Honor, just for the record, it's a municipal ordinance. My office cannot represent her.
I do see that. Thank you. Okay, Ms. Danko Cleary, hello.
Yes. Hi.
You're here on a case from a municipal violation for an open container. I'm going to see if we could resolve your case today, if you'd like to.
Yes.
State, what kind of priors does she have?
For Ms. Cleary,
Yes.
1 second, Judge. I believe they're all MO priors, Judge, but I'll check again.
Well, let me know if you see her MO priors, let me know what she has.
Sure. Open container out of 2017, case number 1772 MO 20A. That's all I'm seeing at this time, Judge.
Okay, so Ms. Danko Cleary, if you'd like to resolve your case today, the court will offer you an adjudication, court costs, and time served.
Okay.
In the alternative, you do have bond set in the amount of $50.
Yeah, I do have that.
Okay, do you want to resolve your case or you want to bond out?
No, resolve my case.
Okay, so let me have you raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. And Ms. Danko Cleary, how do you plead to the open container violation?
No contest.
All right, the court's going to accept your plea of no contest. Court's going to adjudicate you guilty, impose costs, sentence you to time served, and you are all set. You'll be released.
Okay, thank you, ma'am.
You're welcome. Zulma Kazmi?
North Broad, Your Honor.
Thank you.
And again, Your Honor, it's a municipal ordinance. My office can't represent her.
Hello, Mr. Kazmi.
Ms. Cosby.
Ms. Cosme, I'm sorry, ma'am. Okay, now, Ms. Cosme, you are here on a KPS for a municipal violation, and it is for solicitation and display on a public right of road.
Right.
I'm going to see if we could resolve your case today, if you'd like to. You want to do that?
Yes, ma'am.
Okay, State, could you tell me what kind of priors Ms. Cosme has?
Yes, Judge. Ms. Cosme currently has a pending possession of paraphernalia, case number 177389 MO 10A. That's pending in front of Judge Diaz from the city of Fort Lauderdale. We have a 2017 pending solicitation Oh, excuse me, that's this case, Judge. 2016,
Let me ask you something. This solicitation and display on public road, I'm not familiar with this charge. Is it a solicitation as in a prostitution, or is this that?
no, this case is a panhandling case, Judge. However, there are some priors for prostitution.
Okay, but this case specifically is her standing in the roadway and she had a street sign? Is that what it was?
Yes. Yes.
Okay, I just want to, I'm not familiar with this particular municipal violation, so I just want to confirm, is that correct?
Yes, Judge.
Okay, so Ms. Cosme, if you'd like to resolve your case, the court will offer you an adjudication, court costs, and time served. In the alternative, you have a $250 bond.
That was simplest.
Excuse me?
Whichever's the simplest.
Well, I can't make that decision for you.
The first thing you said.
You want to resolve your case today?
Yeah.
Okay, raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. How do you plead to the solicitation and display on a public right of way?
No contest.
Court's going to accept your plea of no contest. Court's going to adjudicate you guilty, impose costs, and sentence you to time served.
Thank you.
You're welcome. Good luck. What? Let's give her 6 months. Okay, Jordan Lee Smith.
Yes, ma'am.
Hello, Miss Smith. Okay, Miss Smith, you're here on DUI charges. The court does find probable cause. You have bond set in the amount of $2,500.
Yes, ma'am.
Your Honor, Ms.
Yes.
Smith, I'm objecting to finding probable cause on count 3. I don't see in the probable cause where there was anyone else in the car with her in particular.
It's an unlawful blood alcohol level over 0.15.
Or?
Yeah.
The only other thing I would ask for Ms. Smith, when I spoke to her earlier, she was asking, Your Honor, if you would sign an order for her to access her property. She wants to access her property that's being held in North Broward.
Any objection from the state?
I'd like to know what the property is.
What property
her
do you
phone
need
and
to
her wallet.
access, Miss Smith?
I was looking for my wallet because then I can just post my bail, but to see if I could do it myself. My parents were notified, but if I have my wallet, I could do it myself too. So.
Okay.
I have no objection to the wallet.
Okay.
Judge, if I could just ask for clarification, is it $2,500 on each count or all?
No. It's 500 on count 1, 1,000 on count 2, 1,000 on count 3, a total of 2,500.
Thank you, Judge.
And the court will allow you to access your wallet.
Thank you very much.
You're welcome. Jessica Marie Wright Butler. Okay. Hello, Miss Wright Butler.
Fine, how are you?
Good. Now, you're here on several charges. You have possession of cocaine, possession of heroin, drug paraphernalia, false ID. Then you have a number of capiases for grand theft, a violation of probation, 2 violation of probations, and another capias. The court does find probable cause. And right now on your cases, you have bonds set in the amount of $3,200 total. However, you're being held on no bond on 3 of your capiases, including 2 violation of probations. You're going to court on August 15 for those matters. Good luck, ma'am.
All right, thank you.
You're welcome. James Smith? James Smith? Hi, Mrs. Smith.
Hello.
You're here on a trespass charge. The court does find probable cause. I'm going to see if we could resolve your case today. Would you like that?
Yes, ma'am.
Okay. Say what kind of priors does he have? Or, you know what, just tell me what your plea offer is, since this is a state case.
Judge, the state would offer an adjudication, court costs, credit time served, no return to the location listed at 1800 North Federal Highway out of Pompano Beach, Florida.
Okay, so Mr. Smith, if you'd like to resolve your case, the offer is an adjudication, court costs, time served, and no return to the subject property.
Yes, ma'am.
Okay. Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, and how do you plead to the trespass charge, Mr. Smith?
No contest.
The court's going to accept your plea of no contest. Court's going to adjudicate you guilty, impose costs, sentence you to time served, and order no return to the subject property. All right, you're gonna be released, Mr. Smith.
Thank you.
You're welcome. William Belgrade? Hello, Mr. Belgrade.
Good morning.
You're here on a resisting without violence and a trespass charge. The court does find probable cause. Would you like to resolve your case today?
I would, Your Honor.
Okay. In the alternative, you have a $100 bond, but state what's your offer on Mr. Belgrade's case?
Judge, state would offer, seeing that this is his first, and I'm saying, withhold court costs on both counts. No return to the location listed at 2551 East Hallandale Beach Boulevard, Hallandale Beach, Florida, 33009.
All right, so Mr. Belgrade, the state's offer involves no conviction. It's a withholding court costs and no return to the subject property.
Well, that is a local Walmart where I do shopping at.
Well, you're not going to be able to go back to that Walmart.
It's the only Walmart in the area.
Sir, you don't have to resolve your case.
All right, it's fine. It's fine, Your Honor. It's fine.
You want to resolve your case or you want to post the bond?
Yes, Your Honor, I'll resolve the case.
Okay, raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. So how do you plead to the charges, Mr. Belgrade?
No contest.
Okay, and I do need to advise you, if you are not a U.S. citizen, a plea of guilty or no contest may subject you to deportation. Do you understand?
I understand, Your Honor.
Okay. You can put your hand down. Court's going to accept your plea of no contest. Court's going to withhold adjudication, impose court costs on count 1 and count 2, and order no return to the subject Walmart on count 2. All right, good luck, Mr. Belgrade. Oscar Badger Lewis.
Northborough, Your Honor. He's a medical reset.
Okay, thank you. Let's reset him for tomorrow. Rupert Crearoy. Hi, Mr. Crearoy.
Hi.
Mr. Crearoy, you're here on 2 municipal violation capiases. They're both trespass charges. You want to resolve your case today?
Yes, ma'am. Yes, Your Honor.
All right. State, does he have any priors? And if he does, what are they?
Judge, he has a pending trespass, that's for these both cases. He has a carrying a concealed weapon misdemeanor, 2016, case number 163917 MM10A, in which he was adjudicated guilty. A 2016 MO case, intoxicating beverages, in which he was adjudicated guilty. Looks like there were a couple of restraining orders that were disposed of. I'm not able to see that. A 2014 prostitution case in which adjudication was withheld. That's case number 1413008 MM10A.
Okay, so Mr. Crearoy, if you'd like to resolve each of your cases, the court will offer you an adjudication, costs, and time served. Do you want to do that?
Your Honor.
Okay. Yes, ma'am?
Your Honor, if the court would consider, we'd be asking for a withhold of adjudication.
Not with the priors that he has.
Okay.
He doesn't have to resolve his case. He could post bond in the amount of $200.
Resolve it, Your Honor.
Okay. All right, raise your right hand, Mr. Crearoy. You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. How do you plead to each of the trespass charges?
No contest.
The court's going to accept your plea of no contest. In case 171025559MO48, court's going to adjudicate you guilty, impose costs, sentence you to time served. In case 172326MO48, court's going to adjudicate you guilty, impose costs, and sentence you to time served. The court's ordering no return to the subject property. You're all set, Mr. Creroy. I'm going to give you 6 months to pay.
Okay, can I also say something?
Yes.
I'm the victim of a little bit.
Okay, Kwok Lee? Hello, Mr. Lee. You're here on a capias for a trespass charge. You have bond in the amount of $250. Do you want to resolve your case today?
Your Honor, can we clarify something?
Yes.
Does the clerk know if the warrant was ever served on him or if it was returned?
Let me see. What did he receive this capias for?
Your Honor, I believe I'm looking at the clerk system. Arraignment was set on March 6, 2017, and then the capias was issued. I'm assuming he never showed up for arraignment. I don't know if he ever received it, but that's what it appears
Okay.
happened. So he's never appeared on this.
It was a missed court date. Okay, and what's the state's offer if you'd like to resolve this case?
Judge, based on priors, well, really no priors, the state would offer a withhold, court costs, and a no return to the location located at, one moment, Judge, 5740 Northwest 46th Drive, Coral Springs, Florida, 33067.
Okay, so Mr. Lee, if you want to resolve your case, the offer is a withhold, court costs, no return to the subject property. Would you like to do that?
Yeah.
Okay, raise your right hands. You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I know.
Okay, how do you plead to the trespass charge?
No contest.
Court's going to accept your plea of no contest. I do need to advise you, if you're not a U.S. citizen, a plea of guilty or no contest may subject you to deportation. Do you understand?
I understand.
Okay. The court's going to withhold adjudication, impose court costs, and order no return to the subject property. Good luck, Mr. Lee.
I release today. Thank you.
You're welcome. Eno Jr. Duversi?
Good morning, Your Honor. Mr. Diversity is at the Paul Ryan facility.
Thank you. Hello, Mr. Duversi.
Good morning, Your Honor.
Mr. Duversi, you're here on an ad charge for a grand theft. You have bonds set on this charge in the amount of $1,000. Good luck, sir.
Thank you.
Andre Burson, Louis Baptiste.
Judge, just for the record, does Your Honor find PC on, diversity on the ad charge?
The court does find probable cause on the ad charge.
Thank you, Your Honor.
You're welcome. Okay, hello, Mr. Louis Baptiste.
Good morning, ma'am.
You are here on an ad charge on a robbery with firearm. The court does find probable cause. What is the state's recommendation as far as a bond?
Judge, the state would ask that you hold the defendant no bond, and find that proof is evident, presumption is great. This is a PBL case. It's a robbery with a weapon. Based on the facts of the case and that this is a PBL, the state would ask that you hold him no bond.
Okay. Does the public defender wish to be heard?
Yes, Your Honor. As for the matter when it comes to finding preventive presumption great, I'm going to cite Yaza v. State, YSAZA v. State. It's a 4th District Court of Appeals. It was decided on June 14, 2017, so the cite I have for it is 4D17-0612. The 4th District Court of Appeals is clear. They've told us before in other opinions that to find proof evident presumption great, that's actually beyond a reasonable doubt. Reading the probable cause here, I understand there might be similarities between an offense that Mr. Luis Baptiste was caught for between a different crime, at a different scene, at a different jewelry store, but he was not caught for that. And what this charge is based on is that the assailant in the earlier incident also used a hammer to break open a pawn shop display case to steal the jewelry. While there are similarities, I don't believe that necessarily rises to proof evident presumption great that the earlier charge with this was Mr. Luis Baptiste. I don't believe it rises to the level of proof evident presumption great. I believe if this was trial day and the state had to actually prove this beyond a reasonable doubt based on the evidence in the four corners of the document, they'd be unable to. Let alone proving proof evident presumption great, which is beyond a reasonable doubt according to the Fourth District Court of Appeals. So I'd ask Your Honor not to find proof evident presumption great, and if Your Honor does not do that, Mr. Luis Baptiste would be entitled to bond on this count.
Okay, thank you for your argument. Let me just review the affidavit. Okay. All right, based upon a review of the public defender, of the probable cause affidavit, I am going to set bond in this case in the amount of $100,000. Good luck.
Oh, sorry. Just for the record, I'm going to ask for a photo order because I see that he's injured.
Your photo order is granted.
Thank you.
Judge, just for the record, this will be over state's objection.
Okay, the court's order is over the state's objection. Good luck, Mr. Louis Baptiste. Demetrius Lamar Jones?
North Broad, Your Honor.
Thank you. Hello, Mr. Jones.
Good morning, ma'am.
Now, you're here on 2 violation of probation warrants. You're currently being held no bond, but you do have a court date on the 15th at 8:30 in the morning.
Yes, ma'am.
Good luck.
Thank you, ma'am.
Randy Michael Johnson?
Randy Michael.
I'm sorry? What'd you say? Okay. Hello, Mr. Johnson. Mr. Johnson, you are here on a cannabis charge and possession with the intent to sell methamphetamines and ecstasy. The court does find probable cause. You have bond set at the amount of $5,100. Good luck.
1 second, Your Honor. Your Honor, he has significant ties to the community. Would you consider lowering the bond?
Is he eligible for pretrial? Madam pretrial?
Based on the charge, he would be eligible, but we have not been able to make a verification on this defendant's behalf.
Okay, does he have any prior state?
Judge, he has a 2013 possession of meth and possession of cannabis. Those resulted in VOPs. A 2013 possession of cocaine with intent to distribute VOP. End of the Broward report.
Those are in 2013?
Those were 2013 cases, Judge.
Okay,
That resulted in violations of probation.
okay. And does he have any prior cases from this court?
Let me take a look, Judge. I will.
While the state is checking on that, if the court is inclined to release him to the supervision of pretrial services, I'm going to request that it be pending verification, since we have not yet been able to make a verification on this defendant's behalf.
Okay.
Judge, at first glance, I'm not seeing that any cases were issued on his previous cases.
Okay. At this point in time, Mr. Johnson, due to the fact that you have priors dealing with the same charges that you just picked up, I am not disturbing the set bond. You could always file a motion in the trial court. Francisco Ceballan? Hello, sir. You're here on an aggravated assault with a deadly weapon without the intent to kill. The court does find probable cause. I am setting bond in the amount of $7,500 and ordering no contact with the alleged victim. Brandon Johnson?
Mark Broad, Your Honor.
Okay, thank you. Hello, Mr. Johnson.
Yes. Yeah. Hello, Your Honor.
Mr. Johnson, you're here on a trespass and you have a violation of probation. The problem that you have is while you have a $25 bond on the trespass, that's caused a violation of probation, which you're being held no bond. So you are going to court on August 15th to address that violation of probation.
Okay.
All right, good luck. You could try and resolve everything there.
Okay.
Good luck. Gabriel Elroy Hill.
Mark Broad, Your Honor, he's approaching.
Okay. Hello, Mr. Hill.
Hello, how you doing, ma'am?
I'm well, sir.
Just Satan been chasing me all day and all night. Satan. But you know, God defeat the devil. I'm staying out of trouble. I go to FCC. I report. I report to my pretrial officers and everything. Her name is Hubbers, and I be letting her know where I go at and everything. And I'm staying out of trouble. And say I go to church and everything.
Okay, so Mr. Hill, you're here on a number of capiases for missed court appearances. You have, looks like 2 separate cases. And right now, you're being held no bond on your felony case. You are going to court on the 16th of August, which is this week, to address that at 8:30 in the morning. And then the next day, you're going to address the misdemeanor case.
Okay, what is this? Is it the same thing or what?
Yeah, you have 3 capiases for one case, and then you have a misdemeanor. Then you have a misdemeanor capias, and you're going to court the very next day. So you're going to be in court this week.
Okay, is this a felony or what?
Yeah, one case is a felony, one case is a misdemeanor.
Okay, what is the felony is about?
You have a fleeing or attempting to elude law enforcement. You have a resisting without violence and a no driver's license. That's part of the felony case. And then your misdemeanor case is a simple trespass. But you'll be in court this week,
But
Mr. Hill.
I told the post office everybody in the post office that
Mr. Hill,
that
I
was
want
a
to talk
cop
about the
killer
facts of your
out there.
case, Mr. Hill. You're going to see your judge this week, Mr. Hill.
Can we get can I order him to get a mental health evaluation?
Yeah, I'm taking all my mental health evaluation as well.
He's in Judge Port's division, and he is in North Broward, so they're taking care of
Oh, okay. All right, you're...
Judge Spicer, yeah.
Judge Spicer, okay.
Okay, so that means he's getting the assistance
Yeah,
he needs?
I went to court yesterday, and the same police officer saw me. He saw me in court, and he just told me to stay out of trouble.
Okay.
Stay to my house and stuff like that.
All right, well, you're going to be brought to court this week, and you could see what you could do to resolve your case.
And I didn't get no kind of
You will.
no arrest reports or nothing like that.
You will. You'll get the paperwork you need. Good luck, sir. Roger Alexander Racer.
Your Honor, can we readdress Francisco Sabayan, please?
Yes.
Your Honor, he's 78 years old and he has early onset Alzheimer's. Would you consider pretrial release for him due to his age and his condition?
State, does he have any priors?
Old priors from the 70s.
Okay.
Assault and criminal mischief from the state of New York. I saw that yesterday.
Okay. You know what? I am I'm inclined to send him to pretrial. What are the conditions that pretrial?
verifiable address?
Does he have an address that's verifiable?
Yes, Your Honor, he does. Where he lives, his home.
Is the court gonna place him on a standard, or would he be on some kind of electronic monitoring?
I'm going to place him on standard. And as long as pretrial is able to confirm his address, he's going to be released on pretrial.
Okay, so there's $7,500 pending verification.
Yes,
Okay,
yes.
so we'll leave the bond in place, and if we can verify him, then we'll take him.
Perfect.
Let me just ask, Mr. Sabaya, your address, is it the address at 21701?
Florida 33029.
Okay, Northwest 7th and Pembroke.
Okay, yeah, that's
Florida?
what's on the police report. Okay.
Okay, sounds good.
All right, good luck.
Your Honor, excuse me, I couldn't hear it pre-trial. Did they say it's standard?
Yes,
Okay.
it's standard, but until his address is able to be verified, he's got a $7,500 bond.
Pending
Okay,
verification.
thank you.
Right, okay. Roger Alexander Racer? Hello, sir. Can you turn the sound on?
There are one more thing regarding Mr. Sabaya. He stayed 500 feet from the alleged victim. No contact with the victim. I don't know who the victim is.
Hold on, let me see the last,
I just wanted to write it on the order.
let me make sure. Okay, no contact with the alleged victim. Okay, Mr. Racer, you are here on 2 violation of probation warrants. You have a no bond hold, but you are going to court on August 15th at 8:30 in the morning. Good luck, sir. Christopher Antoine? Okay, hello, Mr. Antoine.
Good morning.
You're here on a violation of probation warrant. You have a no bond hold. However, you are going to court on August 15th at 8:30 in the morning. Good luck, sir. Jean Autry Graham. I can't hear. Okay, Mr. Graham, you are.
How you doing, y'all?
I'm well, sir. How are you?
Okay.
You are here on a possession of weapon or ammo by a convicted felon, possession with the intent to sell cocaine. You have a drug paraphernalia charge, and then you have 2 violation of probation warrants. The court does find probable cause. I'm setting bond on count 1, the possession of weapon or ammo by a convicted felon, in the amount of $5,000. You have $2,500 bond on the cocaine charge and a $100 bond on the drug paraphernalia. You are being held no bond on the VOPs, but you're going to court on August 15th at 8:45 to address those. Good luck, sir. Justice Akeem Gonell.
Good morning, Your Honor.
Hello, Mr. Gonell. You're here on 2 charges of aggravated assault with a deadly weapon without the intent to kill and criminal mischief. The court does find probable cause. I am setting bonds in the amount of $2,500 on count 1 and count 2, $100 on count 3, and the court is ordering no contact with the alleged victims.
Can I have one second, Your Honor, please?
Yes.
This is for Francisco.
Your Honor, he's been living in South Florida for 30 years. He has significant ties to the community. He's not a flight risk. Would you consider, he's not able to afford the bond, would you consider a bond reduction or some type of pretrial release?
State, does he have any priors?
Judge, from what I've seen, he does have TC priors, all in which adjudication was withheld that I've seen in the state of Florida. If Your Honor would just allow me 1 second, I'll see if there were any previous capiases that were issued.
Stop failure to appear in 2004.
Yeah, I see.
There was a grand theft in 2004. He failed to appear during the pendency of that case. Another failure to appear, and he violated his probation in 2008.
Okay. At this point in time, based upon the prior failure to appears, the court is leaving bond set in the amount that I announced on the record. Good luck, Mr. Gonell. Albert Skiba.
Good morning, Your
Call
Honor.
for out, Your Honor.
Thank you. Hello, Mrs. Skiba.
Good morning, ma'am.
You're here on a possession of Xanax charge. You have bond set at $1,000. The court does find probable cause. Is he eligible for pretrial?
He had a prior trafficking in hydrocodone. Went to Florida State Prison on that charge. He does have a lengthy record if the court orders us to take him.
Your Honor, if I may speak, I
Hold-
changed
hold-
my life around.
Mr.
in
Mr.
2006.
Skiba, somebody's speaking. You're going to wait
okay.
for her to finish.
So Your
Yes,
Honor,
ma'am.
if the court orders us to take him, then, we must, but based on his prior record, we would make a recommendation, as well as his history of failure to appear.
When was his last conviction?
Almost a dozen years ago.
All right, I am just finding out the answer to that.
Judge, I'm seeing the last conviction was in 2006 in Broward.
Okay.
That was when he had the trafficking, and then he was released from Florida State Prison in 2012.
Okay. All right. What I am going to do, Mr. Skiba, I am going to refer you to pretrial services and have.
He could be pending verification. The phone number he gave us to verify his address is disconnected, so we do not have any way to verify him if the court is inclined to leave the bond and put pending verification.
Mr. Skiba, do you have an address that pretrial is able to verify?
I've been there. My family's been there over 50 years. The address is 1789 Northeast 35th Street, Oakland Park, Florida 33334. I've resided there over 5 years. My family's owned it over 50.
Okay, Mr. Skiba, I am referring you to I'm releasing you to pretrial. All they have to do is verify your address, and you're going to be released.
Thank you so much, Your Honor. Have a great day.
You too, sir. Jermaine Hart.
Your Honor, Mr. Hart, the PC I was given, it doesn't give me any information. I don't know if Your Honor, the state has like a different affidavit.
Okay. Hold on 1 second. Hello, Mr. Hart. Okay, and it looks like you have somebody here on your behalf. What's your name, ma'am?
My name is Charlie the Cantrell.
Charlie
The Cantrell.
LeCantro. Okay, and what's your relation to Mr. Hart?
Beyonce.
Okay, very good. All right, so the public defender indicated that there were, oh yes, I do have a probable cause affidavit. No, mine is 2 pages long. You can, here. Do you have one?
I'll give him a copy, Judge.
Okay. Okay, in the meantime, Mr. Hart, the court does find probable cause. I will allow the public defender to review the probable cause affidavit, see if he has any objection. But let me speak with Charlie. Charlie, what would you like to tell the court?
That me and him have been together for 6 years. He hasn't been into any trouble since he has been with me. He's a working father of 5 kids. I really need him home. We don't have much money to post a really big bond. If he can be released on a written promise, or as you guys say, a pretrial or ROR, he will come back to any of his court dates. He lives with me at home with his kids.
Okay. Well, it says here in the complaint affidavit that you sustained several facial fractures. Hold on. Are you the alleged victim in the case?
Your Honor,
I don't
it
think-
looks like this happened back in January. Because what I've been provided with, the date's January 26th, so this is.
Yes, January
Almost 7 months.
January 26th, but the alleged victim's name is blacked out. Were you the alleged victim in this
No.
case? Okay, because I do see it refers to the victim as a he, although I can't see the name. So it does say here that the alleged victim was struck with a closed fist on his face. He fell to the ground. Oh, okay, I see the person's name. It looks like Jamar Brown. Oh, there's 2 alleged victims. And it says here that Mr. Hart took out a box cutter knife, threatened to do violence to the other victim.
Your Honor, I do have I'm printing out a probable cause affidavit without the redactions, if I may approach.
Yes, please. And it says that the first alleged victim sustained several facial fractures in his jaw and nasal bones, along with a scar on his face between his nose and eye. So, ma'am, I appreciate what you're saying, but I am very disturbed by what I'm reading here.
And I can completely understand your concern. With this particular situation that is in question or alleged, he was coming from work. The guy worked with him. The guy was calling him names. The guy spit on him. They got into a tussle. As far as the box cutter, I have no knowledge of that. I was informed from other workers that work at this labor pool that this took place at. He's been working since 6 years since we've been together. He just got a permanent job that he has not missed not one day of, which is where he was picked up from, and they
Okay.
incarcerated him.
Okay. I definitely appreciate what you're advising the courts. What the court is going to do at this point in time, I'm going to set bonds on count 1 in the amount of $5,000 and count 2 in the amount of $2,500, and order no contact with the alleged victims, both of them in this case. Okay. I do wish you both luck. Okay. Adrian Perez?
Or this is another one that I need paperwork on, if you could just give me.
Good morning. He's represented by my office. Christina Cassie, for the record. I'm standing in for Mr. Padowitz, who's attorney of record.
Oh, okay. Okay, so he has private
He does,
counsel.
Judge.
All
I
right.
did have an opportunity to take a look at the allegations against him.
Okay. Hello, Mr. Perez. I can't hear him. Could the public defender turn the system on? Okay.
Hello, ma'am.
That's good. Okay, your attorney is here, Mr. Perez, and yes, continue, please.
Judge, I do know right now he has a no bond. However, I do believe he is entitled to bond. He's not being charged with a capital offense or punishable by life offense. I did have an opportunity to speak with the state. They do have a bond recommendation, but I would be asking for a reduction if Your Honor is inclined to go with the state's bond recommendation. And I'd like to make an argument after Your Honor inquires from the state.
Okay. All right. So I have read through the arrest warrant, and it looks like Judge Bober did issue this warrant on the crime of committing, leaving the scene of an accident with serious bodily injury and tampering with evidence. So I do find probable cause. And what is the state's recommendation?
Judge, the state's recommendation is $50,000 with special conditions of bond, of a level 1 GPS monitor, forfeiture of a passport before being released from custody and not to apply for any new passport, no driving, no alcohol or intoxicants with random testing at least twice a month. I'd also like to make the court aware that the Defendant does have two pending cases. Case number 17-4448-MM10A, it's a possession of drug paraphernalia, and case number 17-1893-MM40A, that's a possession of cannabis. The state would ask that the court revoke bond on those cases.
Okay, and yes,
Your Honor,
counsel?
so in terms of the state's recommended bond, I would ask Your Honor to consider a lower bond amount. In terms of Mr. Perez's ties to the community, he does have family here, both his mother and his uncle. He has lived in Broward County his entire life. He's 21 years old. He has minimal priors. He does not have any assets. So that bond amount for him would be tantamount to no bond, Judge. And at this point, they are just allegations. I don't know if his mother would like to say something and if the court would let her.
Okay, I will if she'd like to. Let me ask the state, on count two, your bond amount that you recommended was what?
On count one, 50,000. On count two, Judge, the state would recommend that the court follow the fee schedule. I believe it's $2,500 on count two.
Okay. Is there an amount on the fee schedule for count one?
No, Judge,
Okay.
not that I've seen.
Okay, ma'am, is there anything, are you Adrian's mom?
Yes, I am.
What's your name?
Veronica D.
Okay, is there anything you wanted to tell the court?
Yes, I'd like to let the court know that my son is not going anywhere. He's not trying to flee. He has turned himself in last week. The sheriff, the police turned him away, and he turned himself in when he was supposed to yesterday. My son is not going anywhere. He has no assets. He lives with his father. He lived with me until up to last year. I have ties to the community. I've worked with attorney Alan Levine for the last 14 years. I'm his paralegal, and I just, he's got pending other charges, but he's entering into drug court, and his attorney is Michael Salazar, and my son has no reason to flee.
And Judge, I'd just like to add to what Ms. Deeb properly indicated. There's no indication that Mr. Perez intends to flee. I know the court wanted a passport surrender. Mr. Perez does not have a problem with that. He, again, has lived in South Florida his entire life.
Yes.
When he was notified to turn himself in, he did so that day. So there's no indication that he's not going to show up for court.
I have the passport with me.
I'm sorry, what day did he turn himself in?
He turned himself in yesterday, Judge, and that was the day that our office was notified that he needed to turn himself in.
And when with the testimony.
Okay. After reading the allegations in the arrest warrant, it's very disturbing to the court what allegedly happened in the case. It says that your son struck a female on her bicycle around midnight back on July 14th. He got out of the car, saw the damage, went to the gas station, and texted his friend, telling his friend that he hit a deer, and the deer died. After that, your son looked online to try and get his windshield replaced. And when he brought that in, he actually also searched the web for hit and run incidents involving a woman. And it wasn't until, it looks like the police attempted to speak with him on August 3rd. And on August 4th, he was advised, the police were advised that an attorney was retained and would not make a statement. So I understand what you're saying and your concern. You're his mother. But the facts of this case are very disturbing to the court. What I'm going to do in this case, on count one, the court's going to set bonds in the amount of $50,000. I am going to set bonds in the amount of $2,500 on count two. The court is ordering a level 1 GPS monitor. He is to forfeit his passport and not apply for another passport. He also is going to be tested randomly 2 times a month for drugs and alcohol. You may not use any intoxicants, Mr. Perez. Okay, and counsel, you're free to file an appropriate motion in the trial court.
Thank you, Your Honor.
Okay, you're welcome. Marcus Rosier?
Yes, good morning, Your Honor.
Just testing. Yeah. Okay, Mr. Rosier, you're here on a violation of probation. There's a no bond hold. You are going to court August 15th at 8:30. Good luck, sir. Michael Joseph Taylor? Hello, Mr. Taylor. Mr. Taylor, you're here on a grand theft auto charge, and you have 2 violation of probation matters. The court does find probable cause on the grand theft. You have a $1,000 bond. On the violation of probation, you're being held no bond, but you are going to court August 15th at 8:30 in the morning to address those cases. Good luck. Jason Hope?
North Broad, Your Honor, he's a medical reset.
Okay, let's reset Mr. Hope for tomorrow, thank you. Rick McKenzie? Hello, Mr. McKenzie.
How you doing, Your Honor?
I'm well, sir. Thank you for asking. You're here on a petty theft, possession of cannabis, and a felony suspended license charge. The court does find probable cause. You have a $750 bond on the felony suspended license. Let me ask, pretrial, is he eligible for pretrial?
This is Mr. McKenzie.
Yes.
Mr. McKenzie refused pretrial services, signed the
Oh,
sheet refusing.
okay.
He also has a pending felony in front of Judge Merrigan. His next court date is September 25th.
Okay, thank you. State?
Yes, the state would ask that you revoke bond on case number 16-000-937 CF10A. That is pending in front of Judge Merrigan, I believe? Yes.
Okay, so Mr. McKenzie, the court is going to leave your bond set in the amount of $750. The court is going to deny the state's motion to revoke your bond in the current case without prejudice. And I would advise that you bring that up with Judge Merrigan.
Yes, Judge.
Okay, good luck, Mr. McKenzie.
What's the bond amounts on counts 1 and 2, Judge?
It's no charges.
No charge? Okay.
Yeah. Owen Fitz Fowler? Where's Owen Fitz Fowler? Madam Public Defender, please turn the volume on.
He's not here. Hold on one second.
Oh, he bonded. Okay, thank you. Frank Minio?
Good morning.
Hi, Mr. Minio. Mr. Minio, you're here on a felony suspended license charge. The court does find probable cause. You have bond set in the amount of $750. Is he eligible for?
Has already contacted the bond.
Oh, okay, so I've been advised that your wife is currently bonding you out.
He's bonded, Your Honor.
You're actually bonded.
Okay.
Okay, Timothy Williams? Timothy Williams?
Your Honor, this is a medical reset. I was just advised.
Okay, we'll reset Mr. Williams for tomorrow, please. Timothy Makish? Hello, Mr. Makish. You're here on a change of charge. The first charge is attempted murder in the first degree. The second is a firearm by a felon. I don't have any of the paperwork.
Yes, Judge, if I may.
Yes.
I spoke with Mr. Linder this morning regarding this case. It appears that the judge, I'm sorry. It's my understanding that the the comments say COC because It's just an additional charge that's being added on. The murder premeditated is not being COC to the attempted murder. However, it just happened to be that they needed to put something on the arrest paperwork, and that's what ended up making it. The previous
So it's
judge,
it's not a change of charge?
that was my understanding through my conversations with Mr. Linder. I'm trying to find if I can just have a quick second.
Yeah, because it says it's a capias, no bond, jail hold for magistrate hearing.
Let's see, 8690.
So there should be some kind of paperwork for the court to review.
Your Honor, I think when he came in, because there's no statute that says attempt murder, when he came in, he was being held no bond. And now it came back as a change of charge because he's actually being charged with attempted murder and not murder.
Judge Frank found probable cause. I do have, here we go. A
If you
copy.
have the paperwork for the court to review, I
I
would
do,
like
Judge.
I'm gonna need to review it also, because I have probably the same thing you do, Your Honor.
that. All right. Let me take a look first, and then I'll let you.
The top page is the probable cause that was found by Judge Frank.
Okay.
It should be an odyssey because he had
It's an odyssey.
Yeah.
Oh, go
Yes,
check Odyssey.
Everything is the same. The only thing was when he was initially booked, as you know, there's no statute for attempted murder.
Okay. All right. Has the public defender been able to read?
Just so we're clear, just so I understand correctly, this is not an additional charge, it's a change of charge. He's still charged with, it was originally premeditated murder, but so they're changing that to attempted murder.
Yes.
Okay, so it's not a separate charge or separate person.
That's right. It's a change of charge from the
I
original.
just wanted to make sure. Having reviewed it myself, Your Honor, if you're gonna hold him no bond, I would just remind Your Honor, you have to find proof of evident presumption, great.
Okay. All right, Mr. Makish, the court has reviewed the probable cause affidavit, and the court does find probable cause. The court is setting no bond on count 1. Is he entitled to bond on count 2?
Judge, you have my paperwork if I could just get.
Oh, sure. Actually, it looks like he is. He is.
That's a mechanical too fire.
Okay, the court's going to set bonds in the amount of $25,000 on count 2, and the court on count 1 does find the presumption of guilt evident and the proof great. Good luck, Mr. Makish. No contact with the victim. Hezekiah James Jones.
No fraud, Your Honor.
Thank you.
Good morning.
Hello, sir. Mr. Jones, you're here on a grand theft of a firearm charge, And you have 2 counts of possession of a weapon or ammo by a delinquent. Okay, the court does find probable cause, and I see we have a deputy here.
Yes, Judge. The state requested that the deputy come in. We were given 24 hours to provide a perfected probable cause affidavit, which Detective Polo was able to file with the court. The state did ask him to come in case Your Honor did have any additional questions regarding probable cause.
Okay, I did not have a problem with probable cause. I do find probable cause.
Your Honor,
So,
the
yes.
objection is, and the reason why it was reset for the 24 hours, is with count, I believe it's going to be count 2 and count 3 of the warrant, that the problem is that in the affidavit, those charges seem to be based on photos and videos. That's how the identification was made in the affidavit. I believe it was a different officer who made the identification through either the photos or the videos. And so the problem that this was reset for is there was no telling that those were actually firearms on those 2 counts, because the identification was made through photo and video, and those weapons were not recovered if they indeed were weapons.
It's the same weapon on all 3 charges, the same weapon, 3 different days. It was live streamed, so we have date and time, and the locations were verified visually by myself.
Okay, the court has reviewed the affidavit. I do find probable cause. And if you want to make an objection, it'll be over the defense objection. A bond is set in the amount of $51,000. Good luck, Mr. Jones. Okay, are there any other issues we need to address? All right, we're off the record.